thank you so much for coming today. I'm Rachel, the president of Advocates for Life, and we would really like to thank the Federalist Society for hosting this event for us, and for William Saunders for coming out. So our speaker today, he's the Senior Vice President of Legal Affairs and Senior Counsel at Americans United for Life. He's a Harvard graduate, and before he went to AUL, he worked for 10 years at the Family Research Council, working on their bioethics and human rights council. And he has been published by Harvard, Georgetown, Catholic University of America, Brigham Young, and in really countries all over the world. He's done a lot of work with human rights and international law. And he's also appeared on BBC World News, CNN, Fox. And so I would just join me in welcoming William Saunders.
Hello, everybody. Thanks to the Federalist Society. I'm actually an officer in the Federalist Society. I'm the chairman of the Religious Liberties Practice Group, so very glad to be here. Also very glad to come speak to the Advocates for Life group, their first, I guess, event, or one of the first ones. AUL, Americans United for Life, which is a lawyers' organization. We have chapters at other law schools around the country, so very happy to have it started here. And you know, I've never been to Bloomington before, and so I was telling Rachel it was kind of nice to drive down. I flew into Indianapolis to drive down just to kind of see that part of Indiana for the first time. I've been up to Notre Dame, hiss, boo, boo, a lot, and but I've never been here before. And it's nice also, I'm a college basketball fan, to come to Bloomington, which seems like a nice place. Although, if you have to be in law school, no place may be a good place to be. I remember law school being incredibly hard and not a lot of fun, but I hope you're having a better experience than me. So what I'm going to talk about today really is the question of, is there an international human law right to abortion? Actually, before I do, whoever is technically proficient needs to take a couple of photos. So it's supposed to be very simple. See, this will, if you need to zoom, you can zoom. If you don't want to zoom, you don't have to zoom. So if you're not technically proficient, and you know, grasp the person who is. So anyway, the question we'll talk about, is there a right to abortion under international law? And I want to do that, I'm going to circle around to it. So I want to first want to point you to you're studying to be lawyers. So the question of whether there's an international right to abortion is a legal question. It's not a political question. It's not a philosophical question. It's not a worldview question. Now, all those things may be relevant in other contexts, but for lawyers, the question is there a law to it? Is there a legal right? If there's a legal right, it's got to be grounded in a document. So what documents are there? Well, one document is the Universal Declaration of Human Rights. Now, you know, technically, the Universal Declaration was a statement issued by the United Nations General Assembly in 1948. It's not in and of itself binding law. It is a declaration, one of the early things done by the General Assembly, and it was done after World War II. So after World War II, I hope you all know and just are aware of how devastating World War II was. Millions and millions of innocent people who were not involved, who were not soldiers, were killed. There were people killed in concentration camps, of course. There were civilians killed as part of bombing campaigns. You know, the targeting of civilians, intentional military action on all sides. So anyway, millions dead. So the UN issued this Universal Declaration. And one of the things it says is everyone has the right to life, liberty, and security of person. Now, the Universal Declaration, like I said, is not a binding legal document, but its ideas were put into binding legal documents, into treaties. So I'll talk about treaties a little bit more in a minute, but the treaty that's kind of most relevant, the one that's the kind of granddaddy of the treaties, is the International Covenant on Civil and Political Rights, Iccpr, International Covenant on Civil and Political Rights. And what does it say? It says in Article 6, every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. Now, just listen closely. My assertion at this point is just very simple. This is what the documents say. So the treaty that's most ratified says every human being has the inherent right to life. And the question we're examining is there a right to abortion? So the first thing to notice is it would be pretty peculiar if there were a right to abortion when the fundamental legal document say that you have the right to life and you can't be deprived of it. Now let me move away from the documents for a minute to a couple of events. This was Dublin last summer, and actually I was there. My hotel is this hotel right here at the corner. If you've ever been to Dublin, it's called Buswell's, B-U-S-W-E-L-L. It's a great hotel. If you ever go to Dublin, you should stay there. I got there about 20 minutes before these people did. This is the largest demonstration there's ever been in Ireland. 60,000 people. And what were they there for? They were there for, as you can see, it's a pro-life march or rally. Because right across the street from Buswell's, over here, this is Parliament, and they were considering a bill to liberalize abortion laws in Ireland. So 60,000 people last summer, they showed up to protest against that. The immediate, now Ireland is one of the 3 most pro-life countries in Europe, along with Poland and Malta. So what did they have to protest about? I mean, if you're pro-life, it's already a pro-life country. Well, the reason is tied to this. I'm not going to go into this in great detail, but I want to give you context. The context is there was a case before an international court called ABC versus Ireland. And I was actually one of the attorneys involved in this case. And the case, as you can see here, 3 anonymous women who wanted to get abortions and said that because Ireland did not permit them to get abortion, it violated their rights under this another treaty called the European Convention on Human Rights. So obviously, Europe is it's a region of the world. It has treaties too. So it's a regional treaty, the European Convention on Human Rights. They said they had a right to abortion under that. Where did the right to abortion come from? Just like the International Covenant on Civil and Political Rights, the word abortion is not mentioned in the treaty. So where do you get the argument there's a right to abortion? They said under 2 provisions, one under the right prohibition of torture, not to be tortured, and then to require them to continue with their pregnancy was equivalent to torture, and under Article 8, which says you have the right to private life and it shall be interfered in rarely by the state. You can see the conditions under which the state can intervene in private life. Now, in addition, they made another argument. Because those 2 arguments, that that torture and a right to private life give you a right to abortion, I think most people thought were pretty weak arguments. They were not impossible arguments, they were pretty weak. So they made another argument. You know, as lawyers and law students, you're always trained to make, in a brief or anything you write, make an argument, have another argument in the alternative. If this fails in the alternative, you have a series of arguments. So their backup argument was that there's an international consensus and particularly European consensus, that recognizes a right to abortion, and Ireland's laws are incongruous with the European consensus, and therefore the court should find a right to abortion. Now, again, the court in the ABC versus Ireland case is interpreting a treaty. I showed you the provisions from the treaty, the torture article, the private life. So it says there's no right to abortion that comes under there. So the European Convention on Human Rights does not give you a right to abortion. And the consensus that they mentioned does not give you a right to abortion. But there was this paragraph. If you've read a lot of legal opinions, you all, there's always, decisions are never as clear as we want them to be, no matter what side of an issue we're on. They're always, so they said this and they say this. And anyway, there's no right under the treaty, but because Ireland had a national Supreme Court case that said a woman who was threatening to commit suicide has a right to abortion, they said Ireland had to change. So in a different case, from 10 years or 15 years before, and this case was decided in 2010. So back in 1990, I believe, or 1991, Ireland has a Supreme Court case saying that a woman threatening to commit suicide had a right to abortion. So they said Ireland has to change its law to make sure that abortion is available in that situation. And this led to a great uproar in Ireland, and abortion became a big political issue. If you followed any of it, if you followed any of this, there was also a case of a woman who died, named Savita, but that's later. This was after 2010. It became a big political issue, and the political party said they would study whether or not to change the laws in Ireland. And last summer, the protest was to say don't change them, but they ended up changing the laws anyway to permit abortion where a woman is threatening to commit suicide. So, another context. So we've gone from the treaty documents to Ireland, just to give you a sense of the fight that's going on around the world. Now this one, which you may have seen in the media, but there was a committee or somebody, the media is never as precise as we are as lawyers, so it said the UN, there is a UN, but the UN is many bodies of different kinds of things. So technically, it was the committee that's formed as part of the Convention on the Rights of the Child. The Convention on the Rights of the Child is another human rights treaty. So just like the Iccpr and just like the European Convention on Human Rights, there's a treaty called the Rights of the Child. And this has a committee under it. And the committee told the Holy See that it had to change its law. It had to change its law to permit abortion when it, in some circumstances, said it had to change its canon law, which is the law of the church, and it had to even review of its normative framework. And also there's certain places where it said it had to ensure a certain interpretation of Scripture went in the direction the committee thought it should go. So, step back, there's this group, this committee, UN we can say, UN committee, that tells the Holy See, or we should say really, a sovereign state that has to change its law, its internal law, and has to permit abortion. So the question you should ask is, where does this committee get the right to tell a sovereign nation, even though it's the Holy See, the Holy See is a signatory to this treaty. So where does it get the right to tell a sovereign nation that it has to permit abortion? Why pick on Ireland and the Holy See? Why pick on Latin America, as I'll talk about in just a minute? The reason is because of the effort internationally to create a right to abortion. It's been in 3 phases. Doesn't have to be rigidly in this time frame, but basically 94 to 2004, 2004 to 2014, and now going forward from this year. So, does international law matter in the USA? Well, okay. First, there's 2 kinds of international law. As I mentioned, treaties. What's a treaty? I mean, you probably all had this in class or whatever, but a treaty is just kind of like this. It's a written document. You sign it. If you're the United States, you ratify it. If Ireland ratifies it and Britain ratifies it, anybody who signs the document is bound by the document, right? And the document, just like if you rent a car, if you rent an apartment, you know, if you buy something on payment plan from a store, you sign a contract. So a treaty is like a contract, except it's between nations, not between individuals, and it's whoever is bound by it is subject to the written terms. I mean, imagine what you'd feel like if, you know, your best friend bought a car and promised to pay whatever, a couple $100s a month. He doesn't pay or she doesn't pay, and the company sues you. And you say, I'm just his friend. I'm not bound on this contract. And wouldn't it be a stinker if you had to pay somebody else's debt? Same thing for treaties. If you're not a party to the treaty, you're not bound by the treaty. So the U.S., for instance, has only ratified a handful of treaties. But every treaty, you know, generally speaking, is ratified. Like the Iccpr, it's going to be bound by that treaty. So that makes common sense. I hope that's what a treaty is. The second kind of international law is customary international law. And all that means, as they say in the Bible, being interpreted or whatever, all it means is it's not one of these things. It's not a written document. So if you want to say, or your landlord wants to say, you know, you as my tenant cannot have, I don't know, people over after 11 o'clock at night on Wednesday. And you say, wrong, pal, not here. It's not here, I can do it, it's not in my contract. The landlord could say, well, it's a custom that everybody observes in Bloomington, or don't observe in Bloomington, but anyway, it's a custom. So it's a practice that's observed by everybody, It's got to be unanimous, and it's got to have grown up over time. So usually, custom would have been things like the way nations interacted with each other, maybe in wartime, or maybe on the high seas, or whatever. But it was national practice. Now, I will talk more about custom in a minute, but do we in the U.S. care about all these international things? Yeah, of course we do, because, among other things, we have the Constitution, which says that all treaties made shall be the supreme law of the land. So you've got to take them very seriously. In 1992, President George Bush the Elder led the ratification of the International Covenant of Civil and Political Rights. But I can just, you know, the U.S. attached a lot of restrictions and said, well, we would ratify this provision, but only to this extent. And back in those days, the U.S. had the juvenile death penalty, so it said we don't ratify, we don't accept that part of the treaty. The point is, the reason that the Bush administration or the Obama administration or anybody in the U.S. president and his State Department has got to be very careful about treaties, because you're bound by them. They're the supreme law of the land, and if you don't want to have a certain obligation, you got to make sure it's not in the treaty. So yes, and then how about custom? Are we bound by custom? Well, there is something called federal common law, although when I was in law school there was a lot of debate. It was what is federal common law, how much does it exist? I don't know if that's still the debate, but as you can see, this Supreme Court case, to some extent, international common law is binding in the U.S. It's not so clear precisely how binding it is. Now, the second point is, though, so it's not as binding, it's not the supreme law of the land, because we saw in the Constitution. So it's a lesser form of obligation, but it still exists. Now, if the landlord said, or said, well, guess what, you've got to not have a barbecue after 11 o'clock at night, and you said, no, it's the custom that everybody can do this, or the other way around, he said the custom contrary. It's not written down. How are we going to know who's right and who's wrong? You have to have evidence. You have to have evidence. They have to say, bring in your next door neighbors, or maybe people from the city council, whatever, and you take testimony and you figure out, is this really a custom? Well, you have to do the same thing with customary international law because it's not written down. So this is what they say in this opinion, this is what the Supreme Court says. You look at customs and usage of civilizations, evidence of these. We look at the works of jurists and commentators who by years of labor and research and experience have made themselves well acquainted with the subject. They are so you're looking to these experts who've studied this, and the courts look to that not for speculation about what the law should be. They only look to that for evidence of what the law is. So if somebody's speculating, it doesn't matter, but the courts will look to the writings of jurists about what the law is. So, one big aspect of the fight over abortion has been the question, is there a customary international law right to abortion? Remember, two sources, treaty, custom. No treaty provides for abortion. So no treaty gives you a right to abortion. So the question is, and we saw that in the ABC case, you can see it yourself looking at the Iccpr, but is custom grown up so that nations have to provide abortion? Well, this is back in 2003, but a document from the Center for Reproductive Rights, which is the pro-abortion group that tries to secure a right to abortion around the world. Their strategic plan was leaked and put in the congressional record by Congressman Chris Smith of New Jersey, and this is quoting from it. So their overall idea is to ensure that governments guarantee reproductive rights, and they include abortion in that, out of an understanding that they are legally obligated to do so. So that means that if governments do it, not because they decide, Great Britain or Rwanda or Mexico decides we want to have abortion. That's not what they're saying. They're saying ensure that they do it because they believe they're obligated under international law to do it. There's two ways, as we've just been talking about. One is treaties, and as they say here, abortion is not protected in treaties. So what's the second way is customary international law, as I was just talking about. But they have a much broader idea of what customary international law evidence is. They include resolutions of intergovernmental political bodies, agreed conclusions at international conferences, reports of special rapporteurs, and comments or interpretations of international treaty committees. I'm gonna work through these a little bit. I want you to just, I know this all may be brand new to you, but I want you to focus on that for a second. With customary international law, everything turns on the evidence. So what's the evidence that the pro-abortion group says we should use? They say we should, remember when we looked at it before in the previous case, Supreme Court had a very limited idea of what we looked to. We looked for only the kind of expert opinions of kind of grand old men and women of international law who study this forever and ever and tell us what the law is. They say, let's look to human rights treaty committees. intergovernmental political bodies, conclusions of international conferences. I'm going to tell you what the problem is with that in a second. So the strategic goal is either adoption of a treaty, which is not going to happen. Remember, you're only bound by a treaty if you sign it. Many nations would never sign a treaty given the right to abortion. So the other principal option is to develop customary international law through this evidence that they were talking about. So that's the question. So I want to look at some of their evidence and evaluate it and tell you why I'm sure that it does not create a customary right to abortion. Well, let's look at the evidence. Now, this is a case from Colombia, from the highest court in Colombia, the Constitutional Court in 2006, and it said it reinterpreted its constitution partially because of this customary international law ideas. They didn't technically find they were obligated to do it, but they said they should understand their constitution in light of these kind of things. And so this is the only court in Latin America that has found this, but it has reinterpreted their constitution, which had an express guarantee of the right to life, to include abortion in these circumstances. That's the outlier case in international jurisprudence. That's the furthest out anybody's gone. But there is a strategy to do this throughout Latin America. And as I said a minute ago, why pick on Latin America? Because Latin America is the most pro-life part of the world. Most countries there either entirely or almost entirely prohibit abortion. So if you want to establish abortion as a human right, you're going after those countries. All right, so let's look at the evidence that was argued to create a right to abortion under custom, under the unwritten right. The basic document, the most important document, the document from which all of the current fighting stems, is from a document from 1994 from Cairo. It was a conference in Cairo, so it's often called the Cairo Platform for Action or whatever. International Conference on Population Development in Cairo. At that meeting, what was it? It was the world convened in a UN-sponsored meeting to consider how to promote how to deal with population and how to promote development. At that conference, the people who believe abortion should be an international human right wanted to establish it in this document, because these documents are issued in a sense by the whole world. When you have one of these meetings, or the UN General Assembly meetings, you have, every nation has a right to be there. Every nation that's a member of the UN, which is every nation I can think of right now. I think except maybe South Sudan hasn't joined yet. But anyway, every nation, so they can all be present. So if you have a document that comes out that says there's a human right, international human right to abortion, and every government should ensure it, you could argue, even though this is like the the Universal Declaration of Human Rights, it's just a declaration, it's not a treaty. You could argue this is evidence of custom. The whole world said in Cairo there should be a right to abortion. That would be your argument. Again, you've got to make the two-step argument, because this isn't a treaty, but you're saying here's evidence of custom. But that's the opposite of what happened in Cairo. In Cairo, there was no statement that there's an international right to abortion. It's just the opposite. They said abortion should not be promoted as a method of family planning, and it was up to individual states to decide how to deal with it. It's up to individual states to decide how to deal with it. It's not an international right binding states. The kind of word, but so that's a big deal. 2004 Cairo. I mean, 1994 Cairo, 1994. But you remember I put that little thing up on the board from 1994 to 2000 as one stage of this fight over custom. So what happens after Cairo? Cairo does not give a right to abortion. It's not evidence of a consensus or a custom in favor of abortion. But in the next 10 years, pro-abortion advocates argued that anytime the words reproductive health appeared in a document, it actually meant a right to abortion, that was included within it. And they meant a very broad understanding of abortion, not a limited one. You can read through this, but you can see what reproductive health is talking about here. Now, a minute ago I said, what's the evidence of custom? One was statements that come out of international meetings. And I said that's bad evidence. Why is that bad evidence, or evidence that can be manipulated? Because every single solitary UN meeting issues a statement. And I don't mean once a year. I mean right now all over the place there are UN meetings going on. There's just been a UN meeting on population development. Before that there was one on the status of women. There are economic meetings. There are meetings on climate change. There's meetings on transportation issues. There's meetings on clean water. There's meetings of regional bodies. Every one of these times issues some kind of document. It's just the way the UN works. So the argument was, since not in all of these, but in many of these documents, they always refer to reproductive health, that showed evidence of a growth in custom in favor of abortion. That was the argument. Now, I should have mentioned this before. One thing that bolsters what I just said about Cairo document was that some nations at Cairo said, particularly from Latin America, they said none of these things mean abortion. So reproductive health doesn't mean abortion, none of them mean abortion. So since if you were going to have evidence of custom, it has to be universal, and since you had a big part of Latin America making it clear that nothing in Cairo covered a right to abortion, it's clear there was no right to abortion at Cairo. So the question is subsequent to Cairo. And in fact, if you think I'm making this up, here's evidence that I'm not. The year Bush Jr. was elected, before it was clear that Bush was not going to promote abortion internationally as the Clinton administration had done. So the Center for Reproductive Rights filed a lawsuit in Southern District of New York claiming that Customary International Law had developed since Cairo to give a right to abortion. And this is the suit they filed. It was dismissed later for standing reasons. And in fact, George Bush, whatever we think about him, about any other context, in this context, he sent the first delegation to the UN, and I was a member of that delegation, private citizen, member of the delegation, and one of the big subtexts was abortion. What language was going to be agreed to or not agreed to. You may find this hard to believe, but I was sitting in the room when it happened, so I could take the oath on this. Remember I said all these documents out of all these UN meetings are saying reproductive health. But they never say abortion. But the argument is, as in that previous case I told you, they say in fact it actually means abortion, but they don't say it in the document. So when we're doing negotiations at the UN, we say, okay, if it doesn't mean abortion, let's put a footnote that it doesn't mean abortion. The other side won't do that. So it's kind of sneaky. It's kind of a sleight of hand. They're claiming one thing in court and another thing in the documents. Well, so we asked, what does this phrase in the document that we're going to issue after this meeting, which was on the World Session on Children, what does equal access to services, including sexual and reproductive health services, mean? The guy said it means abortion. As soon as he said that, all the nations that have laws against abortion had to disassociate themselves from it. The statement could not go into the consensus document. All these UN meetings issued documents, and they all are by consensus. So if one nation doesn't go along, they're not issued. So nations who prohibit abortion cannot agree to language that would include abortion. So in a sense, that the strategy of the other side was kind of brought to light in that session. And the United States attached what's called an explanation of position at the end, like you saw a minute ago. Nicaragua said none of these terms mean abortion at Cairo. The U.S. said the same thing in the statement it attached to the consensus document that came out of the UN Special Session on Children. None of these things mean abortion. None of these things, reproductive health care, sexual health, none of them mean abortion. So, why is that significant? Remember the requirements. You've got to show through custom that there's a universal practice. And here's the U.S. saying the inclusion of the words reproductive health in the document do not mean abortion. You have all the nations there who issued similar statements. So it didn't grow up between 94 and 2001, and then in 2004 there was a Doha International Conference on the Family which repeated the language from previous international agreements, including protection of the child before birth. So 94 to 2004, no customary right to abortion established. Then we have 2004 to 2014, which is, we've been fighting on this because the effort continues, like in Colombia in 2006, to convince courts around the world to recognize the right to abortion. Even in that ABC versus Ireland case, remember their backup argument was there's a consensus in favor of it in Europe. So even if the language of the treaty doesn't, there's a consensus, which means basically a custom, and therefore it should be recognized. So the fight has been continuing. Now, what do we expect going forward from here? Right now at the UN, they're talking about the 20-year review of the Cairo document, which came out in 94. So 94, 2004, 2014, 20-year review. They'll have some kind of program going forward. Will they include abortion in it? They're fighting about that. There's also, you've probably heard of the Millennium Development Goals. They expire 2015. There'll be new internationally agreed goals that are, this time they'll be called Sustainable Development Goals. Will they call for abortion? Will they be, you know. So those arguments continue. Now, what's the relevance about this, again, for us in the U.S.? Well, remember, I mean, there have been other cases, but remember Roper v. Simmons in the Supreme Court, 2005. The question in the case was whether or not the Constitution prohibits the juvenile death penalty. But what I have up here is, so the justices are going to think about that. How are they going to think about it? Well, I believe this was, Justice Kennedy wrote this, but he said, read this. It is proper that we acknowledge the overwhelming weight of international opinion against the juvenile death penalty, resting in large part on the opinion of the world community while not controlling. So what he's saying here is this is not customary international law that binds us. So there's no treaty requiring the U.S. to do this. There's no customary international law requirements to do this. But he says, because, or the majority said, because the opinion of the world community does provide significant confirmation of our own conclusions. So the Supreme Court of the United States could say, now this is talking about if Roe v. Wade were overturned, and the Supreme Court says there's no right to abortion under the substantive due process, which doesn't outlaw abortion, as you know. It leaves it to each state. What if that happens? Well, it's possible the Supreme Court could say, the way our Supreme Court thinks is, well, there's no treaty obligation for abortion. So it's not in our Constitution. There's no treaty obligation. There's no customary international law obligation because all the countries in Latin America have never recognized it, or lots of them never recognized it. But because there's a consensus, or most countries do, that will help us to find a right to abortion. So it's a second or third level but it could be important the way the Supreme Court analyzed it. Here's what Secretary of State Hillary Clinton said. Hillary Clinton said when she was Secretary of State a couple of years ago that reproductive health does include abortion, and that they will protect that right for women. So the Obama administration has been taking the position that reproductive health includes abortion, to the contrary of all the stuff I've been telling you. And I mentioned the Sustainable Development Goals are being negotiated right now. Will they have a separate goal that says reproductive health or reproductive health including abortion as a goal? They're fighting it out right now. And it's, who knows what they're going to say. But up to now, I think it's clearly not been established. So what are some of the things that are being done to resist the development of abortion as a customary international law or as an international consensus? Or one is a project we have at Americans United for Life, which I just mentioned. You can check it out on the webpage. Defendiendo Vidas. It is Latin America. It's an interactive web page where you can move a cursor and you can find out what the laws are in these various countries about abortion. We're constantly updating it, and it's in Spanish, but there's a companion page that's in English. So this Latin American lawyers started this project because they want to resist the people who are saying that that they're under an obligation to recognize abortion. So there's a lot of young Latin American lawyers involved in this. Another thing you should be aware of is the San Jose articles, which you can find on the webpage again at sanjosearticles.com. It's a statement that was released by a number of law professors, lawyers, ambassadors, and others. And it runs through basically what I've said: human life begins. Conception, human beings are entitled to recognition of their dignity. This echoes, this is recognized in the International Covenant on Civil and Political Rights. Remember, we saw that provision at the very beginning of the talk. Every human being has the inherent right to life. It's a scientific fact that new life begins at conception. So every human being, this right is recognized in the International Covenant on Civil and Political Rights. Under basic principles of treaty interpretation, you can read this, and under obligations of the way treaties are usually interpreted, states should read these provisions like an international covenant as giving a right to life. By the way, I haven't made the argument, and I'm not making the argument, that these covenants necessarily give a right to life that would preclude abortion. But I am saying that a treaty that talks about the right to life of every human being cannot be read to give a right to abortion. So Article 6, no abortion under international law. Article 7, this takes us back to the thing I showed you when the committee under the Child Convention told the Holy See to change its law. Every treaty has a committee. It's part of every treaty. They say from the nations who ratify a treaty will elect members to a committee. But the committee's not like a court. It just is supposed to help a nation comply with a treaty. It gives kind of advice. But it doesn't have any right to tell a nation to change its laws. So that's been an abuse. A number of committees have done this, like the CEDAW committee, as it says here, have told lots of nations you have to recognize abortion because there's another treaty called the Convention on Elimination of Discrimination Against Women. Because of that, or because of the Convention on the Rights of the Child, or whatever, you must recognize abortion. So that's an abuse because none of the treaties provide for it, and none of the committees have the authority to tell a nation to change its laws. So, in conclusion, there is not an international human law right to abortion. If the people who want to make that a right can try to pass a new treaty and get nations to ratify it. But I hope you can see by all the evidence that I've gone through that there's no custom that recognizes it. Custom's got to be universal, and there's lots of places that don't recognize abortion. And you can see why some of us are so concerned about what goes on at the UN, because, you know, unless you define terms in the statements that come out of every meeting, you could plausibly argue that a right is growing up to abortion. So that's it. I'll take your questions. Any questions? Yeah.
So you know from ABC versus Ireland that Ireland has been given a very broad margin of appreciation when it comes to interpreting these articles. Why do you think that is? Do you think it's the religious influence or the nature or whatever?
Well, I think that in Europe, that one of the questions in that case was, does the treaty give a right to abortion? And the court said, under the margin of appreciation, it's up to the nations to decide it. So I think, you know, the tradition in the European Court of Human Rights has been that social policy is left to individual countries to do. So I think that's why. I mean, I would have been very surprised if they read the treaty to give a right to abortion, because that's not the way, that's a social issue that's left to the countries usually. Remember when I said the Cairo document, it said expressly that abortion shall be left to the countries to decide. So a country that wants to have abortion can have it, and a country that doesn't isn't forced to. So I think it's pretty traditional, giving them that margin of appreciation. Because now they've started to change their laws, they can change them more. Anybody else?
That was one of the treaties that was talking about the right to quote-unquote healthy offspring. I'm just curious if they weren't referring to abortion there.
That was
particularly
probably
what
the
they were
Cairo
referring to.
document rather than
Okay.
the treaty.
Okay.
I mean, I think it was, my recollection is that that's mentioned in the Cairo, you know, that was the statement that came out of the Cairo meeting. But
Okay.
anyway, go ahead.
But what other elements would the Cairo document be looking at other than abortion and determining healthy offspring? Is that just talking about basic health care services essentially?
Yeah, I mean, yes. It's, I mean, one big issue, I don't know if you're alluding to this, you know, is the sex selection abortion, or disability, serious mal,
Yeah.
I don't know what the word is, but some problem with the unborn. That was not defined in the Cairo document as being a reason for abortion. Now, I don't remember in that document, which is a long document. You can find it and read it or search it online if they define it any further.
Okay.
Oh, yeah.
Had a question. So you said custom is established when states, when it's universal, when every single state practices it. Do you think that, I mean, if we got into a situation where there were only 4 or 5 states that didn't recognize abortion, like would that create a custom?
Yeah, that's a good point, a really good question, because one thing I didn't have time to get into at all, but is there's kind of the traditional way of understanding custom and a kind of what I call a bolder interpretation of the last 25 years, which some professors have even argued that a statement from a single UN meeting can be evidence of custom. Because like I said, remember, you could have when you go to the General Assembly of the UN, there's a chair for every country. Any of these meetings, regional meetings, or any of these conference, the follow-up on conference on Cairo, there can be, you know, every nation's entitled to be there. So the argument's been made, if you have all the nations together and they issue a document that says abortion is a human right, that's evidence of custom. So, yeah, I mean, and given that, and you know, so the old way of doing it is you required unanimity. But the modern way is softer on that idea. And so if you practically had a meeting in which the UN said abortion is an obligation that must be recognized by every nation, and say 2 or 3 nations didn't show up, you know, they just weren't there, I think that the argument would be that it's practically the same. But, and I think most courts would find that way. I think, in fact, you need unanimity to show custom, but it's not always required. So the argument in the ABC versus Ireland case was every other nation except for 2 in Europe provide for abortion. That consensus means Ireland should be required to provide abortion. So that argument could win. Yeah. That's why it's important from a pro-life perspective for countries who don't believe there's a right to abortion to make it clear in their laws that, you know, that they do.
You talked about how, I believe it was Colombia has kind of come out and said there's this international consensus. Have there been other
No.
higher courts that have made that same claim?
Well, in Latin America, there hasn't really been. There's been I mean, it's complicated. The Argentine Supreme Court has said something where we interpreted certain language in its laws in light of custom, kind of like the Columbia court did. So Columbia didn't say customary international law right to abortion. I don't want to be overly precise, but you guys are lawyers, so I need to be precise, right? So it was the same kind of thing as the U.S. in Roper v. Simmons. You know, well, you know, we're not necessarily bound by an international custom, but boy, all this stuff these other countries say is very relevant to us in understanding our own Constitution. And some of that has happened in Argentina. The courts, Supreme Courts of Ecuador and Bolivia have just refused to do that. So I can't think of another example off the top of my head. So it's been pretty limited so far. But Colombia continues to go further and further. I mean, their Supreme Court says not only in those certain cases is there a right to abortion, but they found from the next case that abortion is a fundamental human right. There can be no conscientious objection to it. The government has to put it in the laws. So there's been a progression in Colombia to make it very mandatory. But it's a live, hot fight that's going on right now, and you know, will be fought out. I mean, you know, we'll see how the courts and the lawyers, you know, fight it out. But so far, that's kind of the scoreboard.
I think that's all the questions I have. Thank you so much for coming.
You're welcome.
Feel free to take more pizza on your way out, or a whole pizza.